Well, I believe and I hope that I am live, and I believe that you can all hear me. If at any point, by the way, you don't hear me, if something's not good, let us know, write it in, and we'll try to fix it. But if everything's okay, let me start by welcoming you. My name is Lior Samfiru. I'm the employment lawyer. And why am I here? Well, the reason why I'm here is to talk to you about employment law, to answer your questions and hopefully solve some of your workplace problems. So if you're watching me right now, you may have a workplace question. Maybe you are dealing with an ultimatum. Maybe you lost your job. Maybe something happened where your boss is mistreating and you want to know what to do, what to say, what your rights are. Ask the question. I am live right now. Again, my name is Lior Samfiru, one of the founding partners of Samfiru Tumarkin LLP. We're the largest employee side law firm in Canada, and I'm here to answer questions. Now, let me give you some other contact information before we get started. If you want to connect with me off air, if you want to reach out to me and have a private discussion to me or with my team, just go to employmentlawyer.ca. You see that address below me right now, employmentlawyer.ca. And you'll see the phone number there, the email address there. You can fill out a form with a question and submit it. Everything is right there. So, and of course, there's a phone number right there. You see it on the screen. But that's for later. For right now, for the next 30 minutes, I'm live to answer your questions. Employment law, workplace issues, boss problems, severance problems, losing your job. Ask away. I'm going to start right now, but don't wait till later in the session to ask your questions because we may run out of time, right? So ask your question. First question of the day on YouTube from Amir. Amir asks, am I allowed to record my employer and manager when they're having a meeting with me? I feel like I'm being constructively dismissed. So yes, as long as you're part of the conversation, then you're allowed to record it. Now, you can't record a conversation that you're not part of. So you can't leave a recorder and record your boss and manager speaking to each other. You can't do that. But if they're speaking to you, you can have a recorder. You don't even have to tell them that you're recording it. It is legal to record a conversation that you're part of. But you don't even need to record. Frankly, if someone says something to you and you want to have a record of it, just send them an email or text message after confirming what was said. So that works. And of course, if you have been constructively dismissed, you mentioned that, Amir, just give us a call after that happens, and you can get that information through employmentlawyer.ca. All right. Next question from Ida. On Facebook, Ida asks, can your employer say you're not eligible for the 3 sick days for COVID? So in Ontario, the government of Ontario has implemented a 3 sick days. So it's not up to your employer. If you qualify, then you qualify. So you qualify if you haven't already gotten 3 paid sick days from your employer, and if you have to be off because of COVID. In that situation, then you qualify. It's not up to your employer. They don't have a say in that. But if you've already had 3 paid sick days that your employer paid for, you don't get 3 more from the government. So maybe that's the confusion. If there's any problems, you can always reach out to me again through employmentlawyer.ca, but your employer doesn't have a say. If you qualify, you qualify. It's not an option. It's not a recommendation. It's just the way that it is. Okay, good questions to start off today. Again, those joining us, welcome. My name is Lior Samfiru. I'm the employment lawyer, and we are here to answer your employment law questions, workplace questions, to make sure that you have answers and solutions to whatever workplace problem you may be dealing with. All right, next question from Mark. If I've complied and gotten the first dose of the vaccine and my employer is not demanding I get a booster, which I do not want to, as I've complied with the first 2 doses. Will this hurt my chances at compensation? Should I be terminated for not getting a booster? No, not only does it not hurt your chances, it makes your case that much stronger. So if you're let go because you didn't get the booster, your case is even stronger than it would have been if you hadn't gotten any of the vaccines. So if you lose your job, Mark, first thing you do, or by the way, if you're put on a leave, you call me, okay? You contact me right away, employmentlawyer.ca, again, employmentlawyer.ca, contact information, and let's talk. But no, you're not hurting your case. In fact, you've made your case much, much better. Okay, let's see. I'm scrolling here through questions. Next question today, YouTube, Maria. How are the courts ruling with regard to those being put on an unpaid leave for not supplying their vaccination records per company policy? So there's no court decisions yet, okay? And I don't expect any court decisions until the summer or fall of this year. But we're not really anxious, only because we know what the courts are going to say. Okay, if you lose your job, you're owed compensation, and the courts are going to say that because of that, we're resolving cases now. We're resolving cases every day. We're getting compensation. We're not waiting for courts. We don't need to wait for courts. This is not particularly controversial, if you know what I mean. So if you lost your job, you give us a call. We'll get that resolved for you. Okay, let's see. Next question today. Facebook from Bon Mac. How long can a forced leave without pay go before we can request severance, or do we have to be fully terminated? If we can get it documented in the email that our work issued life insurance will not pay out in the event. Okay, so I'm a bit confused, but bottom line is this. You don't have, the employer doesn't have a right to put you on a leave at all. So you don't have to wait at all. If you've been put on a leave, you can require the company to pay you severance. We would have to get involved for that. And it doesn't matter if you have a good reason or not a good reason not to get vaccinated. If you've been put on a leave, as long as you're not part of a union, again, we're only talking in this session about non-union employees. As long as you're not on the leave, Bon Mac, then you can get severance. You don't have to wait a day, a week, a month. You can choose to treat that as a termination right away. If that's what you want to do, you give us a call. We'll help you get going on that. We've been doing this for hundreds of people across Canada since probably August of this year. Let's see. Next question on YouTube from Maya. I had sent notice of liability to my employer. Unfortunately, I did not receive a response. What should I do next? Well, the notice of liability is a waste of time. It's a waste of paper. You should never do that. It makes no sense. No one's going to respond. There's no obligation to respond. They're not even going to read it. So honestly, you're just killing trees. It means nothing. It's completely meaningless. So bottom line is this: if you lose your job, you're owed compensation. That's all that it is. That notice of liability doesn't do anything. So please, Maya and anyone, do not waste your time with it. Complete waste of time. Let's see. Next question on Facebook from Nancy. I'm a superintendent of an apartment building which is sold. Have no idea if the owners are going to keep me. If they don't, would I get severance? Absolutely, yes. So, Nancy, if you lose your job because of the sale, you're absolutely owed severance. Now, keep in mind, if you live in the building as a superintendent, then they have to also compensate you for the loss of that apartment. So let's say the value of an apartment like that, I don't know, is $1,500 a month. Well, and let's say you're owed 12 months severance. Then they have to add an additional $1,500 on account of the apartment that you have. So if you lose your job, Nancy, call us right away. Number one, we want to make sure that you get the proper amount of severance. And number two, we want to make sure that all components of your compensation are included, including the apartment that you may be living in. Okay? So very good question. I've dealt with hundreds of superintendents over the years, so very familiar in that situation. For those joining us, again, welcome. You're here to learn about employment law. I'm Lior Samfiru, the employment lawyer, one of the partners and founding partners of Samfiru, Tumarkin, LLP, and I am here live answering questions. You see that box on your screen, type the question, press the enter key, it'll ask it, I will read it, I will answer it. So thank you for being with us, and let's continue answering questions. Lots of questions, lots of great questions today. Okay, next question from Amir on YouTube. I'm filing a claim with the Ministry of Labor and was wondering if I can use the recording as evidence. Well, hold on. Stop. Why are you filing a claim with the Ministry of Labor? The only time you should ever file a claim with the Ministry of Labor is if it's an overtime issue, a vacation pay issue, a statutory holiday pay issue. That's it, okay? If it's a constructive dismissal, a termination, a severance issue, you cannot, under any circumstances, file a complaint with the Ministry of Labor. The Ministry of Labor can only recover a fraction of the amounts that you're owed, and by filing a complaint with the Ministry of Labor, you give up the rights that you have to pursue your full entitlements. So no, forget about the recording. Don't do that. If you mentioned something about a constructive dismissal, you need legal advice. You need a lawyer for that. If you don't like me, that's okay. Find another lawyer. But you cannot go to the Ministry of Labor for a constructive dismissal, ever. If you want to reach out to me or my team, easy to do. employmentlawyer.ca. Again, employmentlawyer.ca. See that on the bottom of the screen. Phone numbers are there, email address, everything is right there. Okay. Next question on YouTube from Marilena. Where are we here? I work in a child care center located in a TDSB building, and the TDSB has mandated the vaccine. Will I be entitled to severance? Unfortunately not. Because in your situation, your employer doesn't have a choice. It's not your employer's decision to say you have to be vaccinated. Someone is forcing them. In that situation, because it's not, your employer can't do anything about it, if they let you go, then you're not going to be owed severance. Severance is owed if it's the company's decision to implement a vaccine policy. If it's the company's decision, if they let someone go, they have to pay them severance. But if it's not their decision, they have no choice. They have no ability to decide. Someone is forcing the issue on them, like the government or a third party, like in your case, then unfortunately severance will not be paid. Next question, let's see, from Joker32411 on YouTube. You mentioned that not all federal government employees have a vaccine mandate. My employer, which is a bank, said the government of Canada indicated that they would move in the direction of putting in place vaccine mandate. That's true. They have said that they're going to do that. We don't know if they will. We don't know when they will. We don't know what it will actually say or do. So it's purely hypothetical. But as we speak right now, there is no vaccine mandate for banks. So if you lose your job now, you're owed compensation. If you're put on an indefinite layoff or indefinite leave, you're owed compensation. The government may never introduce that mandate, or if they do, there may be exceptions to it. We have no idea. It's pure speculation. They've announced that they plan on doing so at some point, but I have no idea if that will happen. Okay. Let's see. Next question from Ted Mosby on YouTube. My entire department was fired via Zoom, but was told that they had arranged for us to join another company, but we would have to resign and would not be entitled to severance. Is this legal? Absolutely not. No, not even close. Illegal. I'd like to talk to you. I mean, frankly, if the newspaper heard about that, they're going to want to do a story about that. It's that ridiculous. No. So don't resign. You lost your job. Why would you resign? Of course, you're owed severance. That severance could be significant. It could be as much as 2 years' pay, 24 months. So, Ted, you and your colleagues know under any circumstances you should not resign. No. Call me, email me, employmentlawyer.ca is all the contact information, and let's talk about that, okay? Let's see. The Dreamer on YouTube is next. Are non-compete clauses banned in Ontario? Does this apply even if you signed it before the bill or after the bill came in? So are they enforceable? No, they're not under Bill 27, but only if you signed it after. But keep in mind, they were probably not enforceable anyway, unless you're a senior executive. So for most people, they're not enforceable. And no one, these days especially, it's very unlikely that an employer is going to try to enforce it. But strictly speaking, under the bill, it's only if you signed it after. But again, even before the bill came in, for most employees, our courts have said that a non-competition clause is not enforceable. Okay, let's see. Let's continue today. From Evelyn on Facebook. If a person that is a victim of abuse at work quits their union, can they retain your office? No. So I get that asked often. A unionized employee can never hire a lawyer to deal with their employer, ever. Doesn't matter if you quit, doesn't matter if the union won't help you. Unfortunately, you're tied to the union forever, unless the union gets decertified. So no, that's not an option. And it's because of that, everything that we talk on these sessions, or if you see me on TV and radio, everything that I talk about really only applies to non-union employees. It does not apply to unionized employees. A unionized employee has to go to the union and work with the union, and that's the only option. So unfortunately, if you're listening to what I'm saying and you're hoping that it applies to you, it really doesn't. If you have a workplace issue, you have to talk to your union. Okay, Maria is up next on YouTube. My employer has put me on an unpaid leave and has not provided an ROE. How do I collect EI? Well, you either, if they won't give it to you, we have to get it for you. But it's more complicated than that, because it's not that they just give you a ROE. Depends what it says. You may not qualify for EI. We would need to get involved to make sure that they put the right thing on the record of employment. You're also entitled to severance, again, if you're not part of a union. So we can help you with that so that you can get severance and not just EI. So for that, again, give us a call and let's talk about that. And Maria, reach out to me, reach out to my team, as I've said before, employmentlawyer.ca. Again, employmentlawyer.ca. Next question from Amy. What is the severance wait time at the moment for your offices to get in contact with someone wanting to use your firm? I'm not sure what you're asking. Is it how long it takes to talk to someone at my firm, or how long it takes to resolve a matter? We call everyone back within 24 hours if you leave us a message. To settle these matters, usually anywhere from 2 weeks to 2 months. Okay, that's how long usually it takes to get these matters resolved. Now, Amy mentioned severance. Let me give you another address here. If you want to find out right now, this very moment, how much severance you are owed. If you lost your job, if you're worried about losing your job, or maybe you're just curious, easy. You can use our severance calculator. You go to pocketemploymentlawyer.ca. You see that on the screen soon. Pocketemploymentlawyer.ca. The first thing you'll see there is our severance calculator tool. It's free. It's anonymous. No payment, no credit card information, no names. You just plug in your age, your position, and the length of your employment, and it's going to assess how many months of severance you are owed. And that's effective if you're worried about losing your job, but it's also effective if you're staring at your severance letter and you want to know if what the company's offered you is good enough. Just go to pocketemploymentlawyer.ca, use the severance calculator. I can almost guarantee that you're owed a lot more than what you've been offered, and a lot more than you realize. Okay, so pocketemploymentlawyer.ca. Okay, let's see. Next question. Again, joining us right now, if you are, Lior Samfiru, me. Questions, you. Ask them right now and I'll answer them. From Tucker, how long can my employer leave me on an unpaid leave? So Tucker, as I was saying a few minutes ago, they don't have a right to put you on a leave to begin with. So it's not a question of how long can they keep you. It's a question of, do they even have a right to put you on one? And they don't. So you can treat that leave as a termination of your employment on day one, if you want. So you decide really how long you stay on leave. If you don't want to stay on leave, you can treat that as a termination now, get severance. And if that's what you want to do, you contact my office through employmentlawyer.ca. Next question from Darcy on YouTube. Working for an IT company for 8 years. I signed an employment contract that includes non-compete clause. I'm wanting to leave the company. How do I approach the non-compete clause? So the best thing to do is, number one, if you get a job with a competitor, let the competitor know that you have this non-compete so that they're aware. Next thing, be honest with your employer. Tell them, just so you know, I'm going to go work for this company. I'm going to maintain confidentiality. I'm not going to go after your clients, but I'm going to work there, so that they know. If you can't physically stop them from taking legal action against you, they can. That's why you want your new company to know. If they do, you will win that. But you have to be prepared that they may take legal action against you. But it's far better to be honest and give them the heads up and make sure that they know you're not doing that to hurt them. You're not going to go after them and their business. They need to understand that. And most companies will be fine with that, but certainly have that discussion with them. So Lane asks, next question, is there a purpose for unpaid leave of absence? Mine is 3 months with a termination at the end. Well, I mean, you'd have to ask your employer what the purpose is. From a legal standpoint, your employer does not have a right to put you on an unpaid leave of absence. They don't have a right to do it. You can treat that as a termination now. You don't have to wait 3 months. You can treat that as a termination. We call this constructive dismissal, and get severance now. Okay, so what the purpose is, that's for your employer to say. All I can tell you from a legal standpoint, you can't be, that's not legal. Your employer does not have a right to do that. Okay. Circle of courage. What is constructive dismissal? I just explained that constructive dismissal is a situation where your employer does something to the terms of your employment and you treat that as a termination. An example could be a pay cut, change in hours, a demotion, or being put on a leave of absence. So they're not terminating you, but the law considers that to be a termination. That's why we call that a constructive dismissal. And if that happens, you have a choice to either accept whatever your employer did or to treat it as a termination of employment. And if you treat it as a termination, your employer then is legally obligated to pay you the severance that they would have had to pay as if they had just let you go. Okay, so that's what a constructive dismissal is. Okay, let's see. Next question from Debbie. How many years can you go back to get severance pay? Situation is insurance paid out along with termination, and now severance should have been paid also. You can go back 2 years from the date of termination. Okay, so 2 years. So if you're terminated 2 years ago, you still have time. If it's less than 2 years, no problem. If it's more than 2 years, you're out of time. That's assuming you haven't signed anything accepting whatever your employer's offered, or you haven't signed a release in favor of your employer, but there's a 2-year limitation period. Let's see. Okay. Next question is from Lane. How do we know if our organization has been federally mandated to implement a policy? You ask me. It's as simple as that. You tell me what organization you're working at, I tell you. There's only a very, very, very small amount of workplaces that the government has mandated vaccines. Okay, so, but you're not sure, you just ask me and I'll tell you. Next question is from Amir. I want to get your help, but can't afford a lawyer. Well, most of our cases are on a contingency basis, so yes, you can afford it. Mr. P, do you help with growing options for defined pensions? No, unfortunately, we deal in disputes between employers and employees. Our next question comes from Kathleen. I've been with my company for 2.5 years and being terminated due to a vaccine mandate. Am I eligible for severance or just termination pay? Don't worry about the distinction. When we talk about severance, we're talking about the amount of compensation you're owed if you lose your job. Now, Kathleen, I don't know exactly the job that you've done. I don't know your age, but even after 2.5 years, you could be owed anywhere from 3 to 6 months pay. It could even be more than that if you're older and have a more senior job. So 3 to 6 months pay. Do not worry about the distinction between termination and severance. It's frankly irrelevant. When we use the term severance, we're talking about the compensation that you are owed if you lose your job. Anywhere from 3 to 6 months, that's what you're owed here. If that happens, if you lose your job, unless you've been paid what you're owed, contact me. And as I said, for Kathleen and anyone else, if you want to find out right now how much severance you're legally owed, just go to pocketemploymentlawyer.ca. You see this, the address on the screen, pocketemploymentlawyer.ca. Use our severance calculator, free and anonymous. Find out in seconds how much you're actually owed. Teresa says, I was dismissed by my employer for not taking the vaccine. Well, then you have to give me a call and let's get to work to get you the compensation that you're owed. Let's do that right away. Looking forward to speaking with you, Teresa. Employmentlawyer.ca is the contact information to get in touch with me. For those joining us, still have a few more minutes to ask questions, so ask them away. I'm Lior Samfiru with Samfiru Tumarkin LLP. I'm live answering your employment law questions. Next, let's see. Teresa has a follow-up. My sincerely held religious belief exempt was approved. I was given 2 choices: use my benefited time and 2 unpaid permissive leave. Unfortunately, my boss did not approve unpaid permissive leave. So no, your religious exemption was not approved. If it was approved, you would have continued working. So it was not approved. Therefore, if either of those options happen, you can treat that as a termination and get severance. The decision is yours. Circle of Courage. I'm not sure I understand. When did the law change regarding unpaid leave of absence? It didn't change. It's never changed. Lane says the Métis Nation of Ontario is my employer. There's no vaccine mandate by the government. From Struggling Hustler. That's the best name so far today. Struggling Hustler on YouTube. If someone's employer is constantly asking for vaccine status and constantly giving new deadlines to disclose their status, can the employee claim distress harassment and request severance? Probably not, no. You'd get severance if you're let go because of your vaccine status or if you're put on an unpaid leave. It's going to be very, very difficult to be able to say severance because of the stress. I understand that there's stress. If you can work because of the stress, talk to your doctor, get some stress leave off, but it's not going to be constructive dismissal. Okay. Teresa has a follow-up. I worked for this company for 17 years. I was dismissed for not taking the vaccine. Am I able to collect EI? So first of all, your owed severance could easily be 18 months pay. And with respect to EI, yes, but we would need to get involved to get you a proper record of employment. The record of employment needs to say certain things in order for you to qualify for EI. And your employer may not do it properly, likely won't. So we need to get involved and make them do that and also get you severance. So Teresa, 17 years, long time. You need to contact us as soon as possible to get going on this. Let's see. Darcy asks, if my employer has not paid my overtime according to the company policy and the terms of the employment agreement, and they refuse to pay, is it possible to treat that as a constructive dismissal? Sure, absolutely yes. But before you do that, I want to actually talk to you. I want to see what your contract says, what the policy says, what they've paid, what they haven't, and why. But if they simply said, nah, we don't feel like paying it, yeah, absolutely, that would be a constructive dismissal. In fact, that would be a very easy constructive dismissal. So reach out to me again through employmentlawyer.ca. Let's see. Well, some people complimenting me there. Thank you. Appreciate that. Here, as I said, yeah, do not file. I think I was very, very clear on that. Cannot file. Adriana says, why can't your lawyers not help with EI appeals? We just don't deal with EI appeals. We make sure that you get EI properly to begin with by making sure you get a proper record of employment. We just don't get involved in EI appeals. It's not that we can't, we just don't do it. Debbie, I'm not sure I understand your question. Next question is from Guy. Am I owed any damages if terminated during the probationary period? I was pressured to sign additional agreements and was let go because I raised questions about them. I would have to see the agreements that you signed. The terms of those agreements are going to dictate if your employer owes you anything during the probationary period. So definitely send me that. Next question, I think, and maybe the last question today, is from Diane. Our company has asked us to sign a new contract. If you refuse, they are putting us on working notice. How does severance work with working notice? Very good question. So if your employer gives you enough notice, working notice, they may not owe you any severance. So for example, let's say you're owed 12 months severance. If your employer instead of that gives you 12 months notice, then you may not be owed any severance. But if your employer, let's say, only gave you 4 months notice, they would still have to make up the difference by way of severance. So the first question is, how much severance / notice are you owed, and how much did they give you? Is it possible for the employer to meet their obligations with notice? Absolutely. But of course, I need to assess how much they've given you and what you're owed. So hopefully this is clear for everyone. So I want to summarize this point here because I think some people are still not understanding. If you've been put on a leave of absence, you can choose to treat that leave of absence as a termination and get severance. So yes, your employer is not just going to pay you that severance. We're going to need to get involved. But yes, absolutely, you can get severance. If that's what you want to do, reach out to me. Guys, this has been great. A great session today. Lots of questions. If you still want questions answered, if we didn't get to your question, not a problem. Just reach out to me through employmentlawyer.ca, employmentlawyer.ca, and you can ask questions there. You can email me questions. You can call. You can fill out forms. So many ways to ask questions and get informed. So don't wait till next time I'm here. Don't wait till later this week when another one of my colleagues is going to be here. Ask your questions today. Let's connect. Let's get those workplace problems resolved. Guys, thank you very much. I'm Lior Samfiru. I'm the employment lawyer. Always a pleasure to be here with you. Hopefully this was helpful, and I'll be back soon.